A good vach, Shavua Tov, a good week to you, my holy sisters and brothers. Great to be learning with you on a Saturday night. So impressed with the East Coast people. And I get more impressed as the days get longer and Shabbos ends later and later. Let's light up the darkness. Who's in the house on a Saturday night to begin the week with some beautiful Gemara learning? Sharon in New Jersey, Paul in the Great Northwest, Lucy in Minnesota, Shandora in the Bronx, Bella in Florida, Guy in Ohio, Melissa in Great Neck, David in South Bend, Indiana, Karen in Northern California, Bill in mid-Missouri, Joe in the Inland Empire, Chaim in Florida, Frank in San Pedro, Ella's in the house. Let's do it. We're going to pick this up near the bottom of page 16b here in Tractate Bava Metzia, the 22nd volume of the Talmud. We are continuing our discussion of Mishnah number 6 here in chapter 1. Our daf tonight is Yud Zayin, page 17. Now, near the bottom of 16b, Rabbi Bahu says that Rabbi Yochanan says, with regard to one who finds a promissory note in the marketplace, even if a ratification of the court is written in it, he may not return it to the owner, i.e. the creditor. So we see that there's a lot of opinions about this, lots of nuance and variation. The basic thing that we've been learning, the Mishna said, if you find a promissory note, right, evidence that somebody borrowed a significant amount of money from someone else, do you return it to the creditor, the one who is ostensibly owed the money? An answer, usually not, because we're concerned that the borrower already paid back the loan, and now this promissory note is going to be used to collect on that loan again. Or if that loan is secured by real property, it could be used to seize property either of the debtor or even property that the debtor used to own that was sold to a third party. Now the property will be seized from a third party. Better to turn it in to a rabbinic court. And certainly if you're not sure, turn it into a rabbinic court. But yesterday we were seeing that, well, maybe we're not so concerned that the debtor has already paid off the loan, because if he had paid off the loan, he would have got the promissory note back and torn it up. But then the opinion was put forward that, well, maybe he didn't have a chance to get it back and tore it up. He paid off the loan, and the lender said, okay, I'll get you the promissory note tomorrow. And he was bringing it to the borrower when he dropped it in the marketplace, and that's when it was found. So the borrower, through no fault of his own, could be facing a double collection. Now, he'll say he paid it off, but maybe this lender has lending to a lot of different people, and he doesn't remember by the time that this thing is brought back. So let's keep reading. Okay, so here Rabbi Bahu says in the name of Rabbi Yochanan that one who finds a promissory note in the marketplace, even if a ratification of the court is written in it, he may not return it to the owner, meaning the creditor. So the ratification, this term refers to the endorsement of a legal document by the court certifying that it has examined the document and the signatures of the witnesses and found everything to be in order. A promissory note with such an endorsement may be presented for collection and requires no further substantiation. So you might think, okay, well, what more do you need? That's one you can return to the creditor. And the Gemara explained, but Rabbi Bahu said in the name of Rabbi Yochanan, you don't return it. So the Gemara explains, it is not necessary to say that one should not return the promissory note in a case where a ratification is not written in it. As in that case, there is room to say that the borrower wrote the promissory note intending to borrow money, but he did not end up borrowing it, and therefore the creditor has no rights to the promissory note. But even if a ratification is written in it, one should not return it to the creditor. And what is this authorization? It is an approval that the promissory note has been ratified by the court, which examined the note and the signatures of the witnesses and found everything to be in order. So why can't you return it? The reason one may not return the promissory note to the creditor is that we are concerned that repayment has already taken place. Didn't you say that we're not concerned? Yeah, but then we gave circumstances why we would be concerned. So Rabbi Yirmiyah raised an objection to Rabbi Bahu from the Mishnah on page 20a that God willing will encounter in 3 days. One must return any court enactment, right? So this is a maaseh, right? A maaseh based din, right? So an enactment of the court, right? Maaseh, like an action, something that is created by the courts, right? An action of the court. So nice translation, enactment. One must return any court enactment, i.e. a promissory note that has been authenticated by the court, to its owner. So apparently there is no concern about repayment. And Rabbi Bahu said to him, Yirmiyah, my son, not all court enactments are equal. Rather, the ruling that one must return such a document applies only a case where the debtor, the borrower, has the presumptive status of one who denies his debts. And therefore, if he claims the debt was repaid, his claim is not accepted. But in the case of a normal person where we don't have reason to distrust his honesty, if he says he's paid it off, okay, so we don't return that promissory note to the lender. And in response to this explanation of that Mishnah, Rava said, but does it necessarily follow that just because a debtor assumed the presumptive status of one who denies his debts after one time that he did so, he will never again repay a debt that he owes, and therefore the promissory note should be returned to his creditor? Rather, Rava said the Mishnah is referring to a bill of foreclosure or a bill of authorization, which are not subject to repayment in accordance with the explanation of Rabbi Zera. And the Gemara adds, and with regard to the topic of one who denies his debts, since it came to us, let us say something about it. As Rav Yosef bar Minyumi said that Rav Nachman said, if the court said to the litigant against whom they ruled, go and give the other litigant what you owe him, and later on the debtor said, I repaid him, his claim is deemed credible. And he must take an oath, and then he is exempt from payment. Therefore, if the creditor comes and asks the court to write an authorization for him to appropriate the property of the debtor, they do not write an authorization and give the document to him. Again, this is all in the absence of witnesses, right? So of witnesses to the repayment. So he says, I repay, right? So maybe there were witnesses to the original promissory note, but there weren't witnesses to the repayment. And he says, I paid. And the lender says he didn't pay. Now it's one person's word versus another. So if we don't have reason to distrust the one who says he paid, we allow him to swear an oath that he has indeed paid it, and then the matter is over. By contrast, and now we are on 17a, if the court merely said you are liable to give him what you owe him, but did not complete the process by saying, if the court did not complete the process by saying, go and give it to him, and later on the debtor said, I repaid the debt, his claim is not deemed credible. The assumption is that since he did not pay on his own without the need for litigation, he does not intend to pay until the court finalizes its verdict against him. Therefore, since the debtor is suspected of lying, the creditor takes an oath and collects what he is owed. In this case, the creditor comes and asks the court to write an authorization for him to appropriate the property of the debtor in order to satisfy the debt, and they write the document and give it to him. Right, so there's a lot of very real-world psychology here. Where, in the ordinary course of things, God willing, somebody borrows money, he pays it off. There's no need to ever go to court. If you have to go to the court, okay, and then the court says to him, pay, right? And then the guy doesn't pay. So then the lender goes back to the court and says he didn't pay even when you told him to pay. Okay, so now the court issues this document, go and seize his property from him. Okay, and then the guy can go and seize the property. And at all these different steps, there's a changing attitude toward the lender if he starts to display either contempt for the court or untruthfulness. Right? And ultimately, if you deem that somebody is untruthful, then what's going to be the point of having him swear an oath? And we would shift the burden of the oath or the ability to take an oath from the borrower who says he paid to the creditor who says he was not paid. only because the borrower was deemed not trustworthy to tell the truth, and therefore to swear a valid oath. Rav Zevid says, in the name of Rabbi Nachman, both in the case where the court said, go and give him what you owe him, and in the case where the court said, you are liable to give him, if the debtor subsequently said, I repaid the debt, his claim is deemed credible. Therefore, if the creditor comes and asks the court to write an authorization to seize property, they do not write the document and give it to him. So rather, if there is room to make a distinction between different cases, this is how there is room to distinguish between them. If the court said to the debtor, go and give him what you owe him, and subsequently the debtor said, I repaid the debt, and the witnesses testify concerning him that he did not repay it, when the debt was demanded in their presence, and later the debtor said again, I repaid the debt, so now there's witnesses that he's lying. In such a case, the debtor has assumed the presumptive status of one who denies his debts with regard to that money. And he is no longer believed when he claims that he repaid the debt unless witnesses substantiate his claim. Don't become somebody known as a liar. Obviously, no one will want to do business with you in the future. By contrast, if the court said, you are liable to give him what you owe him, and subsequently the debtor said, I repaid the debt, and the witnesses testify concerning him that he did not repay it, that he did not repay the debt when it was demanded in their presence, and then later the debtor said again, I repaid. In this case, the debtor does not assume the presumptive status of one who denies his debts with regard to that money. His claim that he repaid the debt in the absence of witnesses is accepted after he takes an oath to that effect. What is the difference? That he did not repay it when the debt was demanded in their presence, and later he said, I paid. And that witnesses testified that he did not repay the debt when it was demanded in their presence, and later the debtor said, again, I repaid. I must have missed something, because it seemed like the cases were the same. I would need to read that more carefully, I think. So I'm not sure what mistake I made. Or sometimes there is a misprint in the book. I'm going to continue. What is the reason that he is not... Okay, wait, here we go. What is the reason that he is not presumed to be lying? It is because before the court verdict was finalized, the debtor was merely trying to evade the creditor, thinking to himself, since the court has not yet finalized the verdict, it was the timing, I can delay payment until the sages in the court investigate my case further, as I am not actually liable to pay until the verdict is finalized. And Rabbi Bar Hana says that Rabbi Yochanan says, if one says to another, I have 100 dinars in your possession that you borrowed from me, and the other one says in response, nothing of yours is in my possession, and witnesses testify concerning him that, in fact, he does have such a debt, and subsequently the debtor said, I repaid the debt. So in that case, the debtor assumes the presumptive status of one who denies his debts with regard to that money. It is like the ruling in this case where Shabtai, the son of Rabbi Marinus, wrote a pledge to give his daughter-in-law a cloak of fine wool in her marriage contract. And he accepted upon himself the status of a guarantor for the contract, right? His son got married and offered this, healthy marriage contract in order to attract the prospective bride to marry him. And the father said he would guarantee the marriage contract. And then her marriage contract was lost. And there was a disagreement between the parties as to what was written in the marriage contract. So Shabtai said to her, these matters never occurred. I never wrote that I would give you such a cloak. And witnesses then came and said, yes, he did write her this pledge. Ultimately, he said to them, I paid it. I gave her the cloak. And this came before Rabbi Chia. And he said to Shabtai, you have assumed the presumptive status of one who denies his debts with regard to that cloak. And his claim was therefore not accepted, even by means of an oath. And you can see the problem if he's saying, I never borrowed that money, or I never made such a guarantee in that document. And then later witnesses say, yeah, you did borrow the money, or you did make that pledge to make a guarantee. And then he says, oh, okay, yeah, I made it, but actually I paid it. his story changed quite a bit, and we could see why he would be deemed untrustworthy going forward. Rabbi Avin says that Rabbi Ella says that Rabbi Yochanan says if one was obligated to take an oath to counter another person's claim brought against him, and later he said, I took the oath, and the witnesses testify against him that he did not take an oath when it was demanded of him in their presence, and the defendant subsequently said again, I took the oath, he assumes the status of one who denies his obligations with regard to that oath. Now, it's possible that he's making a mistake. It's like, I know I don't remember making that. That I don't remember taking that oath, or I don't remember borrowing that money. And then later he says, well, what I really don't remember is owing money. So if I borrowed it, it must be that I paid it off, right? And he's not necessarily a dishonest person. And you can see how the wording of this presumptive status that's attached to the person is carefully drawn because they don't say he assumes the presumptive status of one who denies his debts. It says he assumes a presumptive status of one who denies his debts or denies his obligations or swears a false oath with regard to that money, right? In that case, it's not necessarily that he's going to lose all his credibility for all other matters. The rabbis stated this ruling before Rabbi Abahu, and he said to them, Rabbi Avin's statement is reasonable in a case where one was obligated by a court to take an oath. But if one voluntarily obligated himself to take an oath, and he later claims that he took the oath, he is deemed credible. And this is because a person is prone to say incidentally that he will take an oath and then change his mind. Hold on. If one voluntarily obligated himself to take an oath, and he later claims that he took the oath, right? So the difference is between obligating yourself to take the oath and actually taking the oath. So his story changed a little. So he is deemed credible. And this is because a person is prone to say incidentally that he will take an oath and then change his mind. And this does not render him a liar. And the rabbis then brought Rabbi Bahu's analysis back to Rabbi Avin and presented it before him. And Rabbi Avin said to them, I also said this halacha, this law, specifically with regard to one who was obligated by a court to take an oath, as Rabbi Bahu explained. And it was also stated that Rabbi Avin says that Rabbi Ella says that Rabbi Yochanan says, if one was obligated by a court, right? That's the difference between a voluntary oath and one who was obligated by the court to take an oath because litigation was brought against him and he denies that he has this liability. And they say, fine, if you're so sure, take an oath, right? So that's obligated to take an oath. If one was obligated by a court to take an oath, to counter the claim of another person, and he subsequently said, I took the oath, and witnesses testify against him that he did not take an oath when it was demanded of him in their presence, and later the defendant said again, I took the oath, he has assumed the status of one who denies his obligations with regard to that oath. And this wording is explicitly in accordance with Rabbi Bahu's explanation. Rabbi Asi says that Rabbi Yochanan says, with regard to one who finds a promissory note in the marketplace, and a ratification is written in it, and the date of the loan is written in it, and evidently it was written on that same day when it was found in the marketplace, so then the finder must return it to the owner, i.e. the creditor. And the Gemara explains, now before we said, even with the ratification, you don't return it. But now, if it was dated the same day that it was found, okay, because what are we not concerned about? We're not concerned that somebody borrowed the money and paid back the money all in the same day, and then the promissory note was lost on that same day, right? So that sort of stretches credibility, and so we can assume that the borrower has not yet repaid the loan, and so it would be the right thing to do to return this promissory note to the lender. Right? The Gemara explains why there is no concern that perhaps the debtor does not owe the money. If one were to be concerned perhaps because the debtor wrote the promissory note intending to borrow money, but he ultimately did not borrow it, this is not a concern, as there is a ratification by the court written in the promissory note. Since only the creditor would have brought the note for ratification to a court, It is clear that the loan occurred, and if one were to be concerned because perhaps there was repayment, this is not a concern, as we are not concerned that there was repayment on the same day that the loan was taken, since normally one would not take a loan for less than a day. Rabbi Zera said to Rabbi Asi, and does Rabbi Yochanan actually say this? Isn't it you who said in the name of Rabbi Yochanan that one who borrowed money and wrote a promissory note for the loan and subsequently repaid the debt may not reuse the promissory note to borrow another time, as its lien has already been forgiven by virtue of the repayment? So a promissory note is valid only for the debt for which it was written. Okay, makes sense. How does this argue against the idea that a promissory note found in the marketplace that was lost by somebody, dated on the same day that it was found, we can return it? What is the connection? So Rabbi Zera explains, when did the debtor take the second loan? If we say that it was the day after the first loan when the promissory note was written, or another later date, then Rabbi Yochanan's statement is difficult. Why does he specifically give as the reason for the promissory note's disqualification as its lien is already forgiven? Instead, he should derive the disqualification of the promissory note from the fact that it is antedated, i.e. dated prior to the actual loan. And we learned in a Mishna, Tractate Shevi'it 10.5, antedated promissory notes are invalid. Right? You can't write a promissory note today saying you're going to borrow next month, and then you take the loan next month based on, and then the evidence of that is this promissory note that you wrote today. The promissory note has to be dated on the same day as the loan. Although we saw there's a problem with that because maybe a scribe is not available at that time. But let's say we stay with that. So antedated promissory notes are invalid. Therefore, Rabbi Yochanan could not have been referring to a case where the second loan took place after the date of the first loan. So rather, is Rabbi Yochanan's statement not referring to a case where the second loan took place on the same day as the first loan? So evidently, people do occasionally repay their loans on the same day as they take the loan. In other words, from Rabbi Yochanan's statement that you can't reuse a promissory note after you borrowed money and paid it back, and then you need to borrow the same amount again. So you say, all right, you know what? Keep the promissory note. I need to borrow that amount of money again, and we could just use the same note for it. From the fact that he says you can't do that because the lien is forgiven, this teaches us actually that, well, sometimes people would try to do this, right? That they would borrow and repay, and since it can't be antedated, it must be the case that sometimes people would borrow money and repay it and then seek to borrow that amount again on the same day. So if that's the case, how can we assume that money is not borrowed and repaid on the same day? And Rabbi Asi said to him, did I say that people do not repay their loans on the same day ever? No, I said that it is uncommon for people to repay their loans on the same day. Therefore, if a note is found on the same day it was written, it is reasonable to assume that it has not yet been repaid, even if occasionally there's a remote possibility that it was repaid. Rav Kahana says an alternative explanation. Rabbi Yochanan is referring to a case where the liable party, i.e. the debtor, the borrower, admits to the debt. So the Gemara asks, if that is so, what is the purpose of stating that the note may be returned? This is obvious. If he admits that he owes the money, why can't we return it to the creditor? And the Gemara answers, lest you say that even if this borrower admits to the debt, perhaps he actually repaid it. And the fact that the borrower says, I did not repay it, is because he wants to go back and use the promissory note to borrow money again. And the reason he prefers to claim that he has not repaid the first debt is that he is concerned about saving the fee for the scribe, right? To hire a scribe was expensive for poor people, certainly. And that he would have to pay for another promissory note. So therefore, Rabbi Yochanan teaches us that this possibility need not be taken into account, as if that were so, the creditor himself would not allow such a scheme. He would be afraid to act in such a manner, thinking, the sages will hear about me that I reused the note and will cause me to lose the payment owed to me. So the Gemara asks, in what way is this case different from that which we learned in the Mishna on page 12b with regard to one who found promissory notes? that if they include a property guarantee for a loan, he may not return them to the creditor. And we interpreted this Mishnah as referring to a case when the borrower, the liable party, admits to the debt. And the reason that the promissory notes may not be returned is due to the concern that perhaps the debtor wrote the note in order to borrow the money in Nisan, but ultimately he did not borrow it until Tishrei, 6 months later. And the creditor will come to unlawfully repossess land from purchasers who bought the debtor's land between Nisan and Tishrei. And he is entitled to collect land only from those who bought land from the borrower after the loan took place, when the lien was in place on his property. And the Gemara points out, and then we said, well, there's a difference because there are some promissory notes where you say my land is mortgaged from today, even if I don't actually borrow the money until, 6 months from now. So the Gemara answers, the Gemara points out the contradiction between this Mishnah and Rabbi Kahana's explanation of Rabbi Yochanan's statement. And this indicates that we do not say that if that were so, if the promissory note was antedated, that the creditor himself would not allow the debtor to use it, as he would say to him, write another note, dated properly in Tishrei, lest the sages hear about the fact that the date is incorrect and disqualify the promissory note, causing me to lose the money. Again, being the sages being psychologically adept, where they're saying, well, we don't allow antedated notes, but maybe some people will use an antedated note anyway, despite the fact that it's not right. And let's take that into account as we figure out what is the likelihood that this guy already repaid the money or hasn't repaid the money, or that we might put land in jeopardy that the borrower owned and mortgaged for this loan, and then sold it while the loan was outstanding, or he sold it before he took the loan, etc. So the Gemara answers, the sages say that there, in the case of the Mishnah, since the creditor benefits by using this promissory note, as he can repossess land from purchasers who bought from the debtor between Nisan and Tishrei, that it is satisfactory to him, and he does not say anything to the debtor about using this promissory note. By contrast, here in the case to which Rabbi Yochanan is referring, since the creditor does not benefit from reusing the promissory note, as ultimately the note is written for the current date, what is there for him to repossess from purchasers by means of the note that he cannot repossess by means of a new promissory note? Therefore, he would not allow the debtor to borrow more money from him with a promissory note whose lien was forgiven, as this would result only in risk and have no potential benefit. Bottom line, if a borrower borrows money, he writes a promissory note. When he pays it back, he receives the promissory note back and he tears it up. And if he wants to borrow money again, write a new promissory note. And as the lender, you should not accept a reused promissory note because it is invalid. New subject. Rabbi Chia bar Abba says that Rabbi Yochanan says, with regard to one who claims to have repaid a debt that has already been established by a court enactment, i.e., a rabbinic ordinance obligating one to pay a debt, for example, the main sum in a marriage contract, but he has no witnesses, right? Again, somebody who claims to have repaid a debt. Now, either he had that debt, he had that liability because he borrowed money, and now he's saying he repaid it. Or perhaps he was a husband who married a woman and gave her a ketubah, right? So the marriage contract, and he says, if I die, my estate will give you this much money, or if we divorce, I will give you this much money. And then we learn when we study Tractate Kesubos, right? Ketubot, that the sages obligated a minimum amount to be included in the marriage contract, either 100 dinars for a woman who's been previously married, or 200 dinars for a woman, this is her first marriage. And that's the minimum. And then if he was a well-to-do guy and he wanted to, attract a family to give their daughter in marriage to him, and he was gonna, they were gonna expect more in the marriage contract, and they can add more to the marriage contract. And then let's say he divorces her. Okay, so now he has this obligation to pay. So now they come to the court and said, this guy has not paid. And he says, I did pay, right? So if he says he paid, but he has no witnesses to the fact that he paid his marriage contract. Now we're on 17b. So he has said nothing. His claim is not accepted. And what is the reason that he is not believed? It is because one who is owed any money based on a court enactment is considered like one who is holding a promissory note in his hand, against which a claim of repayment is not accepted without supporting evidence. Right now, when we talk about the main sum of a marriage contract, then even if the marriage contract is lost and no one can attest to any other amounts that were included in it, the main sum, meaning that statutory minimum, even in the absence of a marriage contract, the guy owes that, right? And because that main sum is an obligation enacted by the court, right, by the sages generally, so, that's as if a court obligated him to pay, right? That, in other words, they had a contract, he didn't pay, and the plaintiff came to the court and got the court to pass a judgment on him. And so he has to pay that. It's more than just an obligation that was in a document. Now it's a court-ordered payment. And if he denies it, he's going to have to bring evidence that, or if he claims that he already paid it, he's going to have to bring evidence. His word alone is not accepted. So Rabbi Chia bar Abba said to Rabbi Yochanan, but what are you adding? Isn't this principle stated in the Mishna, Tractate Kesuvos 88b, which teaches if a woman produced a get, a bill of divorce, and there was no accompanying ketubah, no accompanying marriage contract, so she collects payment of her marriage contract. She is divorced. It doesn't matter whether she has the actual document, the ketubah, or not. She is certainly owed the principal sum, the main sum, that statutory minimum. So she collects payment of her marriage contract. And this is an example of Rabbi Yochanan's principle that a court enactment enables one to collect a debt even without the relevant document. Rabbi Yochanan said to him, true, this Mishnah is a source for my principle, but had I not lifted up the shard for you, you would not have found a pearl beneath it. In other words, if Rabbi Yochanan had not pointed out the principle, Rabbi Chia bar Abba would not have realized that it was underlying the ruling of the Mishnah. Abaye said, what qualifies this proof as a pearl? It is not a compelling proof, as perhaps in the Mishnah we are dealing with, a place where they do not write a marriage contract. It is not a compelling proof, as perhaps in the Mishnah, we are dealing with a place where they do not write a marriage contract. As in such a place, a woman's bill of divorce is the same as her marriage contract. Right? Maybe in a particular locality, they don't bother to write marriage contracts because if a woman is holding a get, that serves as the ketubah for collecting payment. And this would be for the minimum, right? If they had agreed to a larger amount, she wouldn't need the ketubah for that. But for the statutory minimum, she doesn't even need a ketubah. But in a place where they do write marriage contracts, if she is holding a marriage contract, then she collects a payment. And if not, she does not collect payment. So there is no proof from the Mishnah in support of Rabbi Yochanan's principle. So maybe we have divergence of custom depending on the locality. This is more in the area of regulations than laws and ordinances, right? So Abaye then said, what I said is not correct. As if it enters your mind that we are dealing with a place where they do not write marriage contracts, but in a place where they do write marriage contracts, if she is holding a marriage contract, then she collects payment. Then if not, she does not collect payment. Then, through what means does a widow from her betrothal collect payment of her marriage contract? Since she has neither a marriage contract nor a bill of divorce. A widow from betrothal, right? So as we've seen before, that there were two stages of marriage. There still are. It's just that now in Jewish weddings, on the wedding day, they do both the betrothal and the actual marriage on the same day. But in ancient times, the betrothal would precede the actual marriage, by a year or more, sometimes many years. If a child was betrothed but wouldn't actually step under the chuppah until she was an adult. But if a couple is betrothed, then even though they haven't consummated, even though they haven't stood under the chuppah, the wedding canopy, even though they're not actually married, if he seeks to break off the betrothal, he has to give her a get. He has to give her a bill of divorce. Now, in that case, does he also owe her the ketubah payment? There is no ketubah because they haven't got married yet. The ketubah hasn't been written yet. But does he owe her that statutory minimum? If it is suggested that this widow from betrothal can collect payment by means of witnesses to the death of her husband and that his estate would then pay, so let the husband's heir from whom she is demanding payment come and claim and say, I paid it. She has no proof that she did not receive the money. And if you would say that indeed the heir can claim that he has paid what he owes, well, if so, what did the sages accomplish with their ordinance that a widow from betrothal receives payment of her marriage contract? The heirs can always exempt themselves if they can get away with it, since they don't need witnesses for that. And Mar Kashisha, the son of Rav Chizda, said to Rav Ashi, questioning the underlying assumption of Abaye, and from where do we derive that a widow from betrothal has the right to receive payment of her marriage contract? If we say that this law is derived from that which we learned in a Mishna, Tractate Kesubos 54b, if a woman became widowed or divorced, whether from betrothal or from marriage, she collects all that she is entitled to, both the main sum of her marriage contract instituted by the sages and the additional sum that her husband added, that Mishnah cannot serve as a source for the law that a widow from betrothal has the right to receive payment of her marriage contract, as perhaps the Mishnah is referring to a case where the husband wrote a marriage contract for her. But if he did not, she does not receive any money at all. Maybe she and her family made it a condition of betrothal that she receives a ketubah now. Right? A marriage contract now at the time of betrothal. But if she didn't demand that, there's no statutory obligation that he give that. And maybe he didn't give that. And he was going to wait till they actually got married to give a ketubah. So if you would say, in that case, what is the purpose of stating this law, since it is obvious that she can collect payment if she has a written contract, then one could respond that it is stated to exclude the opinion of Rabbi Elazar ben Azariah, who says that a widow from betrothal does not receive that which the husband committed to pay in the marriage contract, as he wrote the marriage contract only on condition that he would marry her. He did not intend to obligate himself in a situation where he died before they were actually married. Therefore, it was necessary for the Mishnah to mention that a widow from betrothal who has a written marriage contract collects payment, but that does not prove that a widow from betrothal without a written marriage contract collects that statutory minimum that wives collect if the husband dies or divorces her, because a widow from betrothal, in fact, does not collect. That's the law. The halacha is she does not collect unless she got that written written contract. And the language, I'm almost done. Questions or comments, please get them in now. And the language of the Mishnah is also precise according to this understanding, as it teaches she collects all that she is entitled to. Granted, if you say that the Mishnah is referring to a case where the husband wrote her a marriage contract, this is why the Mishnah teaches that she collects all that she is entitled to, i.e., even the amount that the husband added to the main sum of the marriage contract. But if you say that it is referring to a case where he did not write her a marriage contract, then what is meant by the wording, she collects all that she is entitled to? What she has is only the main sum of the marriage contract of 100 or 200 dinars, depending if it's her second or first marriage, that she can collect. And clearly the Mishnah is referring to a case where the husband wrote a marriage contract, and it does not indicate that a betrothed widow receives payment of her marriage contract. And if one would say that the marriage contract of a betrothed woman is instead derived from that which Rav Chia bar Ami teaches, that is also difficult. He teaches one does not enter acute mourning on the day of the death of his betrothed wife. In other words, a husband, right, when his wife dies, he becomes an acute mourner on that day. But one who is betrothed to a woman and she dies, he does not become an acute mourner on that day. Nor, if he is a Kohen, a priest, does he become tameh, ritually impure for her at her funeral if she dies. And similarly, she does not enter acute mourning for him if he dies, and she may not become ritually impure at his funeral, which is an odd statement because that only applies to Kohanim. But there's an explanation there that if it was during a festival when everyone has an obligation to remain tahor if possible, then she would not become tameh to attend him at his funeral. And if she dies, he does not inherit her property. And if he dies, she collects payment of her marriage contract, if she has a marriage contract, but not if she doesn't, right? So betrothal, though it requires a get, is not the same as marriage. Okay, a couple of comments. Joe, one's honor can be easily lost on a lie and or obfuscation, and it is so hard to regain. Honesty is everything. Amen. Couldn't have said it better. Sharon, what level of scribe was necessary for a promissory note? Did it need to be as skilled a scribe as a sofer who writes a Torah or tefillin or mezuzah, or simply someone who could write legibly using the appropriate language required for this type of document? Were they as rare as this daf indicates? It's a great question. I don't know the answer. But I get the feeling that, I'm just guessing, right? So I don't know, but I'm guessing that it's not the same as a sofer, who has to have so much knowledge of all the laws of writing scripture, right? Of writing a Sefer Torah, of writing a mezuzah, writing tefillin, because if not, they're going to be lacking in holiness and might even be invalid. Mezuzah scroll that goes on your door, if it has even a tiny mistake, it does not provide the protection to the family that lives in that house as if it were a valid scroll. In terms of this promissory note, probably it's a little bit less expertise because you don't need all those laws of Kedusha. You really just need to know the commercial laws of loans. But you wouldn't probably just want your neighbor Jerry to do it, because I think there is a bit of, knowing the laws of loans, right? And that he would make sure that the questions, and we've already seen that the scribe who writes a promissory note is obligated to ask questions. Are you including a guarantee for real property? From when does that guarantee run? If the loan is not paid off, can the lender seize that property? Does he have to go to court? These are the questions that a lawyer would ask, right? So, if you're borrowing $100 from your neighbor, then maybe Jerry, the other neighbor, could write that promissory note for the two of you. If you're borrowing, enough money to buy a house, so I think it would be wise to get a proper lawyer, a proper scribe who knows those laws. I remember years ago I saw this Broadway play called Other People's Money. I think they made a movie out of it with Danny DeVito. And right, Danny DeVito has the line, lawyers are like nuclear weapons. The other side has theirs, so you gotta have yours. An expensive undertaking. Sharon, what if there is a prenup? Does this rise to the level of a ketubah? It's interesting. If we're talking about under Jewish law, I would say that the prenup would be written into the terms of the ketubah. If we're talking about how does a prenup in civil law intersect with the requirements of a ketubah, that's a really interesting question. We've already seen, right, that Dina de Malchus Dina, the law of the land is the law. And there I would definitely say, make sure you have both a good lawyer and a good rabbi. That's what I've got for us today. And with God's help, we'll be together again tomorrow, Sunday, at the regular Sunday time, 6 p.m. Pacific.